appeal in the matter of recovering Partners GP Ltd and another, and Rudhadze and others. Partner.
Yes, Mr. Weisberg.
My Lord, my Lady, I was on the factual background in relation to ground 1. And if I may now show the court the phase 2 judgment, so picking that up, call 1, tab 9, page 206. Sorry, the phase 2 judgment. I'm sorry. Phase 2 judgment.
Yeah, sorry. Can you give the reference again? I'm
yes.
really sorry.
Phase 2, call 1, tab 9, page 206. And one picks up the judge's factual findings from paragraph 419 and following. And the judge notes in paragraph 420 that there are issues both as to the existence of the agreement and as to its terms, and we say that that's right. Then in paragraph 422, she makes what is in effect a legal point. There's a threshold point. Principle as to antecedent agreements, which I've outlined above, relates effectively to agreements which define the extent of the principal's interest, and we'll look at the law in the moment. She says this is not such a case because whatever the state of play as regards agreements to remuneration division of the spoils, they were or would have been agreements under the umbrella of SCPI. So SCPI had the business opportunity and was to contract with the family. 100% of the interest in the MBO was out of SCPI. The principal as to antecedent agreements therefore is not engaged. And we say that she's right on that. She's right on the finding that she made that it's SCPI's interest. Indeed, that's not challenged on this appeal. And we also say that if that is right, as it is, then the principle as to antecedent agreements is not engaged. Nonetheless, she goes on to look at, in paragraphs 424 and following, at the underlying factual position in relation to that allegation. And one can see in 424 that she deals with the 40% initial deal, as she puts it. Then she points at 425 to the spreadsheets, and I've shown the court paragraph 122 of the phase 1 judgment already. And one can then cut down to 426, where reliance at that stage was being placed on what the revoker proceedings said, i.e. the revoker proceedings were the proceedings brought by Mr. Jaffe against a number of the former revoker executives, and I'll show the court those pleadings in a moment. But 427 is the important paragraph. It is an important paragraph in that there's a series of, we say, unappealable factual findings in that paragraph. One starts with the first sentence. On this point, my conclusion is that the defendant's position is not entirely correct. So she rejects the submissions that have been set out before, at least in part. And what she says is it pays too little regard both to the overall complexity of the relationship and the lack of focus by these parties on formal contracts or the English law. So, pausing there, first point she makes relates to the overall complexity of the relationships. And even from the limited exposure that this court has had to this case, that may strike the court as being something of an understatement. Then she says that there is a focus on the lack of focus by these parties. So again, she's looking very particularly at what these parties were doing. And plainly, again, we say that is, those are issues of fact that were in her mind. She then goes on to say in the following sentence, the reality is the situation as between SCPI and the family and Mr. Jaffe and Mr. Rudhadze was in a state of flux. What is meant by a state of flux? We would say it means three things. First, it means no intention to create legal relations. Second, we say it means no certainty as to the facts of an agreement. And thirdly, we say there's no certainty as to the terms of an agreement. Both the issues of the fact of the agreement, the existence, and the terms were particular provisions identified by the judge in paragraph 420, as I showed the court. But we say that is clearly what the judge had in mind when she uses the concept of state of flux. Then in the next sentence, she makes, again, an important finding. Just as SCPI did not quite achieve an agreement with the family, despite coming close at times, so too did the position as regards entitlement of the Park Street team remain some way short of contract. Now, what always is that is self-evident. In circumstances where SCPI had not yet agreed terms with the family, why would it have agreed the terms with those who it would be using to provide services to the family? It may, in principle, have said these things might happen. Mr. Jaffe's evidence was he was entitled to allocate, as the controller of SCPI, where particular profits might go, once the profits had been made by SCPI. But the judge was, we say, entirely entitled to say that, consistent with the lack of agreement with the family, there was a lack of agreement between the revoker members, including in some part the Park Street team, and Mr. Jaffe, as to how allocations would be drawn up. Then, in paragraph 48, the judge looks at the defendant's own pleading, and I showed the court that pleading yesterday, and it is worth noting that it appears that the defendant wishes to disassociate themselves from that pleading, whereas at the same time, in the context of the revoker pleadings that I'll show the court in a moment, at trial at least, it was a core part of the defendant's case that Mr. Jaffe was doing something inconsistent with what he had said in the revoker proceedings. We don't accept that, and I'll show the court those documents in a moment. But then paragraph 49 looks again at the spreadsheets, and the Kira Gabbett spreadsheets show in essence what Mr. Jaffe was prepared to pay, and crucial words, at any given point in relation to the business then due to result in any payments into SCPI. So again, pausing there, it's Mr. Jaffe deciding what to do, it's Mr. Jaffe deciding at any particular point in time, it's Mr. Jaffe deciding in relation to payments into SCPI. And at various points in my learned friend's submissions, it appeared to be suggested that it was a question of the fiduciary retaining amounts of money that were to be paid to him, i.e. Mr. Rudhadze would receive the money, and Mr. Rudhadze would then hold back some money and pass some money on. That wasn't the structure that the parties anticipated. It certainly wasn't the structure that the judge found in circumstances where it is SCPI that has the interest, and it is then revoker, which is the entity that's set up as a partnership. And part of the judge's findings at phase 1 is that the duties owed by Mr. Rudhadze and Mr. Alexeyev were owed at least in part by the fact of their membership of the LLP. Then the judge says the SCPI executive spoke of the shares as entitlements, and she uses inverted commas, and we say with good reason. The shares were moved without any formal process. Again, that's a factual finding. The spreadsheet reflected the realities of who was contributing to the current paying projects and the likely division of the spoils. Mr. Jaffe thought of them as, in some sense, binding, as he said in the revoker litigation, but nothing was fixed. And again, we say those are crucial factual findings that this court should not interfere with, and were plainly open to the judge on the evidence that she'd heard. It's at this stage that it's important to look at the revoker pleadings, and those are in supplemental bundle 1, and they start, please, at tab 19. Page 265 for those using the electronic bundle. These were proceedings commenced by Revoker LLP against Mr. Khan, Ms. Gabbett, Mr. Nagel and Mr. Blumkin. And in essence, what these proceedings sought to do was to make clear what would happen in the event that an account of profits generated money for Revoker as part of these proceedings. And what one sees from these proceedings is at paragraph 1.2 the form of declaration that the claimant was seeking at page 266. The claimant seeks declarations that Mr. Eugene Jaffe is entitled to determine the economic interests of each of the defendants in the profits and or assets of the claimant, and has validly done so in a determination reached by him on the 11th of October 2018. And then one cuts on to page 267. We see, and this is only an extract from the particulars themselves, but paragraph 21 shows on the 11th of October 2018, formal declaration. Mr. Jaffe decided that he should treat each of the defendants as being hostile to the claimant by reason of the matters set out earlier in the pleading. Mr. Jaffe decided to make adjustments to the economic interests that the defendants might have in relation to the proceedings, and he determined that they'd forfeited the rights. And then paragraph 22, Mr. Jaffe was entitled to make the determination by reason of the fact of his control of the claimant, and by it being accepted, agreed, and or understood by the members of the claimant that he had such an entitlement. And then reliance was placed on Annex 1. And Annex 1 starts at page 269. And this sets out details as to the various economic interests that Mr. Jaffe allocated to the various individuals involved with the recovery services at various moments in time. And one sees at paragraph 6, Mr. Jaffe alone had the power to decide which executive would work on which project and which economic interest any given executive would receive on the various projects. In deciding what economic interest, if any, would be given to any executive, Mr. Jaffe would take into account a number of factors, and then those factors are set out. And then what one sees in paragraph 8, throughout the course of any given project, Mr. Jaffe increased and decreased or altered the economic interest of the executives, taking account of factors such as those set out in paragraph 7. Although he often made these decisions having discussed the matter with others, including executives, any decision in this regard was always within his sole discretion and his alone. And then at paragraphs 9 through to 17, there are allegations as to how the particular shares shifted. But we say the case was always clear. The case was that Mr. Jaffe alone was entitled to allocate, he was entitled to change his mind, he was entitled to reduce or increase the allocations given to any executives, and those executives included Mr. Rudhadze. So the suggestion made by the defendants at trial that the pleading was in some way inconsistent with the case as being presented by the claimants in these proceedings was wrong. The pleadings were entirely consistent with the approach that the claimants sought to adopt. And just to complete the picture, if one goes to the reply, which is at tab 21 of the same bundle, and please go to page 281. So at this stage, the only active defendant was Mr. Nagel. Mr. Khan, Ms. Gabbett, and Mr. Blumkin had all reached terms with Revoker. So this was the only defence that came to be served was by Mr. Nagel, and this was the only reply that came to be served. And in 8.4, what one sees is Revoker pleading to Mr. Nagel, saying that Mr. Nagel had previously recognised Mr. Jaffe's sole authority to determine questions of remuneration. In an email to his father and daughter on the 13th of April 2011, he outlined his entitlement. In relation to MIG, which was one project, Mr. Jaffe would honour his word that I have 15 to 18% range at Mr. Jaffe's discretion of what comes to London after Irakli is paid out. In other words, recognising the entitlement was dependent on Mr. Jaffe's word, and the precise amount was a matter for him to determine in his discretion. And then in paragraph 8.42, Mr. Nagel used the word grant or granted. And we say that is consistent with the approach that the claimants argued for at trial, and indeed that the judge accepted. If one then goes on to page 282, we see a plea in paragraph 33.2, denied that the arrangements for the remuneration or percentage entitlements of members of the claimant were merely interim arrangements. The income to which those arrangements were intended to relate had not been definitively fixed with the family, but the arrangements were binding. Now that's the passage that was relied on at trial. The judge, rightly, we say, took that into account. She looked at the revoker litigation, but that was to be understood properly by reference to what else appears in the other pleadings, namely that they were binding so long as Mr. Jaffe didn't decide to change his mind. The very reason for these proceedings to be brought was that Mr. Jaffe had exercised his power and wanted a declaration that he had properly exercised the power and was entitled to do so. In those circumstances, the judge's findings on this point are, we say, unimpeachable. One can put away Supplemental Bundle 1 and go back, if we may, to the Phase 2 judgment. So that's Core 1, Tab 9, page 207. And it's paragraph 430. We've looked at 429. 430, the problem for the defendants is that this is what the judge finds. The recovery service has not been formalised with the family. The shape of what was to be done and how things would move forward was not in place. Without that, an agreement as to entitlements in respect of that work could not be in place. It would be a case of putting the cart before the horse. Now, my learned friend sought to put a lot of weight on the word could in that particular paragraph and could not be in place. Now, obviously, a judgment is not a statute. It's clear what the judgment and what the judge meant. In this particular circumstance, where those matters were not formalised with the family, the suggestion that there was some binding antecedent agreement that, come what may, whatever the relationship with the parties might be, the parties as between Mr. Rudhadze and Mr. Jaffe, be going forward, there would never be a change to these allocations, is, we respectfully submit, not one that should be countenanced. Indeed, it's not one that the judge is finding as a matter of law. The judge is finding as a matter of fact that in those circumstances, given her knowledge of these particular parties, no such agreement could be in place. She continues then on paragraph 431 to look at the shape of the likely agreement in the third line. And that is, again, an important finding. She says the form of the likely agreement can easily be discerned. The reality of the situation is that while no formal agreement was in place, again, we say a finding of fact, there was a common understanding in the run-up to the breaches that Mr. Rudhadze would receive or have a right to dictate the allocation of somewhere in the region of 50%. And again, we say that is a finding of fact. There is uncertainty, even as to the crucial term on which the defendants seek to rely. And my Lord Justice Phillips, during the course of my learned friend Lord Wilson's submissions, made suggestions as to the types of other terms that one might need to agree, as to whether it's an equity share, whether it's a cash share. But even in relation to the core term on which these defendants rely, the 50%, there's a factual finding that goes against the defendant's position. And we say that is a factual finding that was open to the judge, which this court should not interfere with.
So there's a whole other side of the agreement as to what they had to do in order to earn their share.
Absolutely. And if the court goes back to look at some of the underlying Phase 1 judgment, what one sees is from about May 2010, there is a falling out, or the beginnings of a falling out between Mr. Rudhadze and Mr. Jaffe, and Mr. Jaffe and the family. And the suggestion that an agreement was concluded in 2008 as to exactly what would happen, and then all that happens in 2010, or as I understand it on the defendant's case, is the 50% is then increased, belies the reality of the relationship between the parties, which was, as the judge has put it, in flux. And then the judge looks at an email from Mr. Jaffe contemporaneously in 2011 And there Mr. Jaffe talks in the language of would have perfected. That is consistent with the judge's findings, in that it is finding that something might have happened, it might have been perfected, but it was not perfected because of the issue being dragged on by Irakli. And again, if the court goes back to look at the Phase 1 judgment, what the court will see is that that is Mr. Jaffe's version of what then was going on between him and Mr. Rudhadze. Then in paragraph 433, the judge makes again a factual finding that it reflects the reality on the ground. And then 434, she makes again a factual finding. If it all had gone forward, absent breach, and there were no other changes in the interim, that is what would most likely have happened. So pausing there, two important provisos. The first proviso is that all would have gone forward absent a breach. And the second proviso, that there would have been no changes in the interim. Of course, neither of those provisos came to be satisfied, because Mr. Rudhadze, Mr. Alexeyev, and Mr. Marston decided to break away and effectively take the opportunity for themselves. Now we say the judge's factual findings were all open to her. Her reasoning on those issues of fact is clear and unimpeachable, and that is in fact the end of this particular appeal. But I'll need to elaborate on that submission briefly when I come to my submissions. That's all I want to say at this stage about the facts in ground one. I then need to look at the law in relation to ground one. And we say that there are four key cases that answer at this particular point. And we've set out in our skeleton argument, paragraphs 10 to 15, what we say the relevant legal principles are, and I don't intend to repeat them. The four significant cases, we say, are Regal Hastings, Boardman and Phipps, Murad, and Gray. At the risk of showing the court material that the court is already well familiar with, I would like, if I may, just to show some passages of Murad and some passages of Gray. Murad is in Authorities Bundle 2, tab 18. And one can pick up the analysis, if we may, in Lady Justice Arden's judgment at paragraph 67, which is page 530. And 67, the fact that the fiduciary can show that the party would not have made a loss is on the authority of Regal an irrelevant consideration. And importantly, then likewise it follows in my judgment from the Regal case that it is no defence for a fiduciary to say he would have made the profit even if there'd been no breach of fiduciary duty. And we say that in essence, that is exactly what these defendants seek to do. A similar comment is made in paragraph 71 on page 531. In my judgment, it's not enough for the wrongdoer to show that if he had not been fraudulent, he would have got the consent of the party to whom he owed the fiduciary duty to allow him to retain the profit. The point is that the profit here was in fact wholly unauthorised at the time it was made and has so remained. To obtain a valid consent, there would have to be in full and frank disclosure. Now, there we say, this is exactly the situation. It's not a full and frank disclosure situation because the defendants were clear they were going to take the opportunity even if the claimant wanted to exploit the opportunity itself, which it did. Then paragraph 101, it is the court repeating the well-known principle set out in Parker and McKenna as to the importance of this particular rule. And we would just emphasise the words in the final part of the extract from James L.J. in Parker and McKenna, cited at 101, for the safety of mankind requires that no agent shall be able to put his principal to the danger of such an inquiry as that. What type of inquiry? The inquiry is to receive evidence or suggestion or argument as to whether the principal did or did not suffer any injury in fact by reason of the dealing of the agent. And we say that is exactly, again, what this defendant or these defendants seek to do. Those are the particular passages in Mura that I wanted to show the court. Then, if I may, I'd like to turn to Gray in the Court of Appeal. That's Authorities Bundle 3, tab 28. And I'd like to pick it up, if I may, at page 852, which is paragraph 126. And that's an important paragraph for many aspects of these appeals. The point we wish to emphasise is that the basic equitable rule is indeed a stringent one, which requires an errant fiduciary to account to his principal for all unauthorised profits falling within the scope of his fiduciary duty. The rule is intended to have a deterrent effect and to ensure that no defaulting fiduciary can make a profit from his breach of duty. It does not matter if the result is to confer a benefit on the principal, which the principal would otherwise have been unable to reap. And then there's a citation from Snell. And then just at paragraph 128, the important point, this is about 5 lines down, the important point in our judgment is that the liability of a defaulting fiduciary to account for unauthorised profits is a strict one, which has always been jealously enforced by courts of equity. There needs to be some link or nexus between the breach of duty proved and the profits for which an account is ordered, such that there is a reasonable relationship, but the link or nexus does not need to be close. And we say in many aspects of the defendant's appeal, particularly when one comes to look at the ground 2 relating to delay, in many ways the answer to that appeal lies in the reasonable relationship. And when one looks at the cases, and I'll expand on this point when we come to it, when one looks at the cases, what is really being sought is the reasonable relationship. Time may be relevant in some circumstances, not unconscionable delay, but the time link for the purposes of working out whether there's a reasonable relationship between the particular amount of money that has been received by the fiduciary and the claim that the trustee seeks to make. My lords and my lady, those are the only legal submissions I think that I need to expand on for the purposes of this ground 1. I'd like then please to turn to the third area of my submissions, which relates to my submissions on ground 1. And as we have made clear in our skeleton argument, we discern 2 particular forms of challenge. The first is a challenge to the scope of the account. The second challenge relates to the allowance that was then granted. And it's the slight oddity of the way in which this appeal has been opened by the defendants is that your lordships and your ladyship has heard very little on the allowance part of the submission, because that's being left by Mr. Burt to answer me. I'm not going to take a point on it, because I can answer the allowance submission in any event. But all I do say is, in the event that Mr. Burt expands substantially in relation to the allowance submission, it may be that I need to reply a little more than I might otherwise have done when one comes to my reply submissions, but I'll leave that where we are for the moment. What we say is we have 6 overarching submissions in relation to this ground 1. 2 are of general application, 2 deal with the scope submission, and 2 deal with the allowance submission. And I'll take them in that order. So the first submission is one of general application, and that is a submission picking up on a point that I made to the court yesterday. Namely, it's important to bear in mind that the opportunity was being pursued by SCPI. And there's a real danger that this ground of appeal, in practical terms, seeks to open up an issue that has already been determined in phase 1, that was then repeated in phase 2, because what it seeks to do is to carve out from the opportunity an element of the case. On my own friend's case, 50%, even on the judge's case, somewhere in the region of 50%. On Mr. Cogley's case, below 40%. We'll come to that. We say that's not appropriate. And what the court should not find is that, in effect, the defendants had, as a matter of right, as a matter of legal right, an entitlement to this amount. And that, we say, would run counter to the judge's findings. And if my learned friend says in reply, well, no, I accept the judge's findings on that issue, then the true nature of the defendant's arguments becomes clear. Because what one then sees is happen is that the defendant's case is actually directed at seeing how the profits earned by SCPI might have been distributed after being earned or received by SCPI. And put in those terms, it becomes clear that this is res inter alios acta. It is incidental. And any agreement does not affix itself on the equity of the profits. There may or may not be a claim at law. No claim of law has ever been articulated. And as Mr. Wolfson accepted, there's never been a suggestion by the defendants that they are still legally, contractually obliged to provide my clients with 50% of the profit that was actually achieved. But that is the natural corollary of the defendant's case. So we say, when one views it from a proper analytical perspective, the defendant's case is looking at res inter alios acta. This is not a form of equity that bites on the account. It is something entirely separate and independent. So that's the first submission. The second submission is one that we say the defendant's case fails on the facts. And I've shown the court the clear factual findings that the judge made. We say on the basis of those clear factual findings, it's unclear how this challenge gets off the ground, particularly in circumstances where my own friend accepts paragraph 17 of their skeleton argument that there is no challenge to the judge's factual findings. Whether or not there is an oral agreement, and what the terms of that oral agreement are inevitably matters of fact. The interpretation of the terms or the legal effect of the agreement is absolutely a matter of law. But whether or not there was agreement and what the terms of the agreement were is a matter of fact. And for that we've cited Lewison, paragraph 4.13, Authorities Bundle 3, tab 29, page 948. And as I've showed the court, the judge rejected the suggestion there was a binding agreement. She properly weighed the evidence before her based on the knowledge of these parties. And this is one of those rare cases where the same judge has had the opportunity both at the liability trial and at the account stage to make specific findings about each of these witnesses and consider the evidence given by each of the parties by way of oral evidence and by way of documentary evidence. There were 15 days of the first phase trial. There were 27 days of the second phase trial. There were a vast number of documents and there was very detailed cross-examination. The judge was properly immersed in this case and in those circumstances to look at snippets of evidence, snippets of the factual case in the way that the defendants seek to do, is, we submit, not an appropriate way to proceed in this court. Moreover, when asked by the court in this appeal as to the nature of the agreement for which the defendants contend, it became very difficult to see what the answer in fact was. As to parties, as I pointed out yesterday, my learned friend didn't even mention SCPI. As to terms, as I've already pointed out, there's uncertainty over the percentage. There was also uncertainty over how this process would actually work. My own friend yesterday suggested that 50% of the profits would be retained by the fiduciary. As I pointed out earlier, that's not what, in practice, we submit would have happened. The fact of that uncertainty, even now, is consistent with a party that has failed to discharge the burden of proof that was on it, both as to the existence of the agreement and as to its terms. Moreover, none of those uncertainties should lead the court to think anything other than that the judge's findings were right. But that said, what challenges are made by my learned friend, and one can take them hopefully with relative speed. The first point that my learned friend takes is by reference to paragraph 430 of the judge's judgment. 4.1, tab 9, page 207. And this is the paragraph we looked at a moment ago. What the defendant says the judge found as an overriding point the lack of agreement with the family precluded the existence of a profit-sharing agreement. And that, they say, is the overriding point, and that's the main point they attack. But we say that the judgment is much more nuanced. It's not as monotonal as the defendants seek to suggest. As I showed the court, she looked at the complexity of the relationships. She looked at the lack of focus on formal contracts. She looked at the state of flux. She looked at the lack of agreement with the family, absolutely, but she also looked at the defendant's own pleaded case, which contradicted the allegation of a settled agreement. She looked at the spreadsheets. She looked at the revoker litigation. This was, by its very nature, a multifaceted evaluation of the evidence. So we say that challenge simply doesn't work. And one point that my learned friend in that context says is, well, he says it orally and in writing, that the judge was wrong because parties usually want to establish their financial entitlements and mutual rights and obligations before they start working on and committing themselves to a project. The problem with that is that Mr. Rudhadze was already working for SCPI at the time that the recovery services became available. He was involved in the Georgian operation. Mr. Alexeyev was recruited as an employee to be involved with the recovery services, and Mr. Marson was also recruited as an employee, paid a limited amount of money by way of salary and bonus. So that commercial reality does not have any, if it is a commercial reality, does not have any role to play in this case. Moreover, in relation to the dealings with the family, precisely the reverse happened. Substantial work was done by SCPI between 2008 and 2011. There were non-binding term sheets, but in no sense were those terms agreed with the family so as to be legally binding, so as to then be able to bring a claim in respect of amounts that were then to be due. Indeed, there were protracted negotiations, and one of the reasons why, on the defendant's case, the relationship between Mr. Rudhadze and Mr. Jaffe broke down was because of a failure to be able to agree with the family how much should be paid. Moreover, this submission proceeds on the erroneous assumption, the defendant's submission proceeds on the erroneous assumption that the defendants were parties to a business venture, or joint venture. It's not that. As I've already said, they were employees working for SCPI, working as members of Revoca in the case of Mr. Rudhadze and Mr. Alexeyev at a later date. So in summary, on this challenge in relation to 427, we say three things. We say that the defendants mischaracterised the judge's conclusions. We say that the reliance on commercial reality is dangerous and it is an ephemeral guide in circumstances where the judge was looking at the underlying facts of this particular case. And third, the judge's findings of fact are nuanced and are not liable to be displaced. The second criticism that is made, also in relation to paragraph 427, is the judge's comment on the lack of focus on English law requirements for a contract and the lack of a formal agreement. Now, we accept that it is, of course, legally possible for a contract to arise without a formal process. But those may indeed be relevant factors as a matter of fact. The factors identified by the judge may be relevant as a matter of fact to work out whether or not a contract had in fact arisen. The judge is not saying in no case can an agreement arise. Rather, the judge is saying that in the facts of this particular case, no agreement did in fact arise here. In this context, my learned friend looked at the question of revocability. And the judge also looked at the question of revocability at paragraph 619 of the judgment. And if we could go to that, please, which is at page 242, what we see there is the judge finding that the absence of discussion about the issue of revocability was consistent with the absence of any agreement. But if there was an agreement, then it was revocable in the event of breach. And in many ways, those findings are unsurprising, and indeed we say obvious. But 4 points arise in relation to this part of the judge's judgment. The first, it is my learned friend's criticism of the judge's use of the subjunctive in paragraph 624. With respect to her grammar is impeccable. If there had been an agreement, it would have been one that provided for revocation. The subjunctive is apposite in circumstances where she's making an assumption that there was an agreement contrary to her factual finding. And if there was, then it would have been one that provided for revocation. And again, we say that's a factual finding plainly open to her. She was taking a thoughtful and careful approach. She was not wrong in the approach that she adopted. Second, in the context of revocability, my own friend sought to suggest that the officious bystander would, if he had or she had intervened, to ask what would happen if there was a breach of loyalty and the parties went their own ways, the parties would have said that the 50-50 agreement should stand, notwithstanding the breach. Now, we don't accept that. It's never been suggested before now. Why would the parties want a 50-50 deal to inure whatever might subsequently transpire, particularly in circumstances where this was a relationship that was in flux? And if that really is the defendant's case, why isn't the offer of 50% being made, and why has it never been made?
Excuse me, in order to say what the what terms might have been implied in, as a matter of law or otherwise, you first have to identify the nature of the contract. And as I didn't understand, Mr. Wilson even ventured onto that territory, it's very difficult to see what the content of the discussion could be.
In some circumstances, it's suggested by the defendants this was a private equity type relationship. But it plainly wasn't, because recovery services, conducting litigation, finding assets, identifying assets, and then seeking to recover them for a third-party family is not normally, at least from my experience, part of the private equity business. So absolutely, my lord, I completely endorse your lordship's view that absent knowing what the agreement is, it becomes very difficult to know what should be implied. Moreover, the burden is on the defendants to show the nature of the agreement and, in relation to this appeal, to displace the judge's findings as to the fact that the agreement, whatever it was, would have been revocable.
Well, as I understand the very indisputable structure, SCPI would have had to have been a party to the agreement. And on the basis that there would be some form of remuneration paid. But that, on the face of it, would be you'd expect that would only continue for so long as the relationship which gave rise to the remuneration continued. It's not a controversial proposition that employees or consultants or whatever only get paid whilst they are engaged. So I'm not sure where the starting point of any of this is.
With respect, I agree. And I think that is probably all I need to say in relation to my second submission, which is on the facts. The judge was right. Then turning to my third submission, which relates to the scope submission, we say that the defendant's approach is legally unprincipled. And we say it's legally unprincipled because it would run counter to three important legal principles. First, it would undermine the policy justification that any allowance cannot have the effect of encouraging fiduciaries to put themselves in a position where their interests conflict with their duties. That's Guinness at 701. This agreement, if it was an agreement, would give the defendants a free hit. And that can't be right. The second principle that it would contravene is that it is legally irrelevant to consider whether the profits could or should otherwise have gone to the principal. And that's Regal Hastings and Gulliver 144G to 145A, and Gray in the Court of Appeal at 126, which I showed the court a moment ago. And we say that the agreement contended for would do precisely that. It would seek to determine whether or not the profits would or could have gone to the principal. The third principle that we say would be contravened is that it would contradict the authorities which establish the irrelevance of the counterfactual hypotheses as to how much the claimants or the defendants would have earned but for the breach of duty. And that's Murad at 71 that I showed the court a moment ago. And we say, my learned friends, three scenarios don't answer those core points. These three scenarios where the arrangement didn't have to be legally binding. It must be legally binding in order to get around these three principles. But even if it is legally binding, then it doesn't matter whether it's a hand in the till case. This is his second scenario. Because these three principles would still bite on the particular contract that he seeks to rely on. And his third scenario was the actual allowance, and I'll look at that in a moment. So our fourth submission in relation to scope is that the judge's approach on the law was unimpeachable. And one picks up the law as found by the judge at paragraph 359. That's page 192 in Core 1, tab 9. We see the judge looking at Murad, looking at Churnside, looking at Keystone and Parr, in a way that we say is entirely correct. Indeed, my learned friend didn't seek, as I understood his submissions, to challenge anything that the judge found in relation to those three cases. She reached the conclusion at 363, which we say is right, that the authorities went so far as to say that where there's an antecedent agreement which limits the principal's interest, the fiduciary need only account for profits in respect to the principal's interest. And that makes obvious logical sense. My own friend accepts in his skeleton argument that Murad doesn't help insofar as the agreement was insofar as there was the agreement didn't bite and the agreement didn't continue, he sought to rely on Lady Justice Arden's comments that the hypothetical share with the Murads might have given him if he disclosed the set-off arrangement is not relevant to this argument, because it was never actually agreed or put up as a contribution. That's paragraph 87. He suggested, I think, that, as I understood him, that this was a recognition by Lady Justice Arden that had there been such an agreement, where it was in fact an arrangement agreement that was in place, then that would have subsisted and been given effect to. We don't accept that. We don't accept that's what Lady Justice Arden would have meant. It would have run entirely contrary to, for example, the passages that I showed the court a moment ago. In relation to Keystone, that's Authorities Bundle 3, tab 25, the defendants accept that the antecedent agreement bit, or assert that, but they assert that there was no clear analysis. We say the judge's analysis in 362 is absolutely right. The claim was for the entirety of the amount that he should not have received had the articles been adhered to. So in that case, the antecedent agreement was in fact the basis for analysing the undisclosed profit for which the fiduciary needed to account. So it was the basis of the claim. On that basis, it's entirely unsurprising that the agreement was held to bite, because it was the very document, the very analysis that the claimant was seeking to rely upon for the purposes of identifying the undisclosed profit. So we say there's good sense in that approach. It is in principle appropriate to distinguish between antecedent agreements that limit the principal's interest and those that do not. That respects the deterrent effect, and insofar as the defaulting fiduciary can satisfy the court that they should be entitled to an equitable allowance, then they'll be able to receive payment in that way. Not by way of profit share, not by way of entitlement, but as a result of the proper identification of the equitable interest that falls to be protected, and then an allowance if that's appropriate. So we say that's the answer to this scope here. My friend makes a number of other submissions, which if I can just pick them up very quickly. The first submission that he makes in writing is that there was no authority on the issue, and that's in his defendant skeleton, paragraph 26.5. Sorry, that's our skeleton, 26.5, answers that point. There we rely on CMS Dolphin, which is Authorities 2, tab 15, which is a decision of Lawrence Collins J, where the debt claim for the past salary up to the point of departure was held permissible. There was no suggestion that any claim for further sums that would have been paid if the fiduciary had remained loyal. And that is the core, we say, of this 50-50 antecedent agreement, if there is any such agreement, which there isn't. The core was on the basis of loyalty, then X. That's the first point. The second point is that my own friends say that the distinction drawn by the judge is arbitrary. They say that in their skeleton, paragraph 23. And they posit, as the court will recall, a number of hypothetical examples. We deal with those in our skeleton, paragraph 26.6. But in short, the distinction is not arbitrary. It properly reflects the fact that some arrangements will impact on the interests in respect of which fiduciary duties are owed, and others will not. And moreover, in this case, where the opportunity was that of SCPI, as I said, any decision by SCPI as to how it would then pay the money on after it had received the benefit is res inter alios acta. So the hypothetical examples relied on by my learned friends don't assist at all, because a 20% shareholding is different from a contractual entitlement 20% of a company's profits. There's nothing arbitrary in equity or in law about respecting that structure. There is something arbitrary about seeking to rely on a post hoc distribution by a principal as a basis for defining the scope of the account. That's the defendant's case. Inevitably, a proprietary interest has a different legal effect to a personal interest, and an agreement between some parties which impact on the extent of those parties' interest in the venture is different from an agreement which does not. So, my lords, my lady, we say that as a matter of submission, the judge's approach was unimpeachable and the court should not seek to go back. Subject to your lordships and your ladyship is all I want to say in relation to scope submission. I can take the allowance submission relatively speedily. Our fifth submission is that the allowance submission, as it's now put, 50%, was disclaimed at trial. And if I can just show the court where we say that disclaimer took place, it's in Supplemental Bundle 2, tab 35, page 558. So this is an extract from day 27 of the trial on phase 2. This is part of the defendant's closing submissions by Mr. Cogley, and one can pick it up at page 171 of the internal pagination at line 16. We add to that the following point. I accept, of course, you can't have an allowance that gives you everything that you've got as a result of being in breach of fiduciary duty. But we're not asking for that. We're not asking for that at all. This is on the basis that we use many of our other arguments. We are not asking to be put in the same position. In any event, that's wholly artificial. And we say those concessions were entirely well made in light of the law. Then one cuts down to line 11, where the judge says, let's start at line 4. It's not so much that you can't have an allowance that gives you everything that you've got as a result of being in breach of fiduciary duty. The point is more, can you really have an allowance that gives you everything that you'd have got if you hadn't breached that duty? Mr. Cogley says yes, and effectively the 50-50 approach. And then Mr. Cogley says, the 50-50 would do, I accept that. Sorry, I'll start again. The 50-50 would do, I accept that. I would give everything that they'd asked for in the first place. I accept that. And I believe that we've proposed that there should be a discount to that, and I think we've ended up with 40%. So there are two concessions there. The first concession is, in principle, the defendants can't have the full amount of the allowance by reference to the 50-50 agreement. The second concession is that they'd ended up with 40%. The sixth submission that I make in relation to the allowance.
We're pausing there. Why should they not be permitted to withdraw that concession in this court?
With an explanation as to why. It may well be that they could withdraw the concession made below.
Why what? Lord Wilson has explained why, in his submission, it was wrongly made.
Well, we would want an explanation as to why the 40% concession was made in the first place, as to 40%. Why then the 40% was arrived at, and why now they should be released from the concession they made below.
not a very formal concession.
I accept that. And I don't seek to attach too much weight to that particular concession, because I've got plenty of other points. And the sixth point, the sixth submission is indeed the point that I make, which is that it's wrong in principle to use an antecedent agreement to set the amount of the equitable allowance. And we develop that submission in paragraph 29 of our skeleton, and I'll develop that submission further when we come to look at allowances in a moment. But the short point is this: if you can bring back an antecedent agreement into account when setting the equitable allowance in full, you're back in the territory of allowing the fiduciary to be in a heads I win, tails you lose situation. It is pure try your luck territory. And the courts have been stringent in preventing fiduciaries from doing anything which could impact on their duty. And the deterrent effect would, we say, be entirely undermined. And in that context, the only case that my learned friend, Lord Wolfson, showed the court was O'Sullivan. That's Authorities Bundle 1, tab 11. There, the antecedent agreement did not shape the account because it was unlawful. It had been procured by undue influence. And what happened there was that the court said that fair remuneration or reasonable remuneration would be the touchstone. And that's Lord Justice Waller at page 312H. We submit that that is the entirely orthodox approach. The court should look to see what is fair remuneration or reasonable remuneration. And as I will hope to show in our appeal, that was not something that the defendants sought to do. They adopted an entirely different approach. They adopted an approach of seeking to show unique and exceptional skill. They adopted an approach of showing an increase in value in the assets. They failed in both of those attempts. The first attempt as to unique and exceptional skill, the judge made findings of fact rejecting it. In relation to increase in value, the defendants simply didn't seek to articulate that case at trial at all. So the suggestion that in some way this antecedent agreement can be brought in by the back door to then set the allowance in firm 50% territory is, we respectfully say, wrong in principle, and the court should not allow Ground 1 to go any further. I'm about to move to Ground 2. That might, subject to the court, be a convenient moment.
Can I ask you one thing? The judge, in looking at whether there was a finalised contract, thinking about paragraph. Refers to the pleadings.
I'm sorry, Lord, I missed that.
So it refers to the pleadings in 428, the defendant's own case in phase 1. I just want to understand what this means. My understanding is that the pleadings were the pleadings in the case.
Yes.
And there was no phase 1 at the time of the pleadings.
Correct.
And your particular claim claims an account or compensation. The judge here makes the point that it was their case in phase 1. Why had it ceased to be their case in phase 2?
Because in their position paper, they sought to say that it was an antecedent 50-50 agreement.
And they can do that, can they, without amending their pleading?
Well, there was a suggestion that that was an abusive process, but in the end, the judge said, I'd make just findings of fact, and made findings of fact on that particular point. I completely agree, my lord. It is difficult to see how, in principle, one could advance in a position paper a case that is entirely inconsistent with the pleaded case by way of defence, but that's what happened in this case.
So did the judge effectively treat treat that pleading as having been superseded or amended. It wasn't discussed.
It was. I mean, so abuse of process is mentioned by the judge in paragraph 421. And certainly the pleaded position was that it was an abuse of process, and indeed, list of issues 19 asked whether it's an abuse of process. But in practical terms, one can well understand why the judge and the parties in front of the court wanted to engage with this issue rather than just taking.
Normally, you're bound by your pleadings, aren't you?
My lord, absolutely. I
It
wouldn't.
does look from 421 as though I haven't seen the terms of list of issues 19, but it does look as though the battleground was: are you entitled to take this stance in your position paper for phase 2, given your previous pleading, to which the judge says the answer is yes.
Well, I think
Is
what
that
the judge.
fair?
I think what the judge says is it wasn't pursued with much enthusiasm.
And it doesn't have an effect on the outcome.
But because she goes on to find two things. One, the antecedent agreement wouldn't have made any difference anyway. And secondly, there was no agreement. And even if there was an agreement, it was revocable. So at trial, one can well understand why one doesn't seek to put one's case solely on the issue of abuse.
No, but you haven't, in any way, you haven't put in a respondent's notice.
I say we've got plenty of material here to make with the judge.
Thank you.
I mean, it does appear to me, at least, that it was one of the factors that the judge may have taken into account in reaching her conclusion.
Yeah.
That there was no.
Your Lordship's absolutely right. I think I would read the judgment in the same way.
Yeah.
And plainly, she was entitled to do so,
That's a
even
different
without
point.
finding there was an abuse of process.
Yes.
Should we take our break now, then, if you're going to go on to the next one?
Case Authorised.
So, ground two, alleged unconscionable delay. Deal first with the factual background. So we deal with the relevant factual background in paragraph 30 of our skeleton. I'm supposed to show you just very briefly some of the underlying materials again. First, the re-amended defence, which is in supplemental bundle 1, tab 15, page 117. And what one sees there is the way in which the account and the question of time are catered for. I'm picking up at paragraph 106 on page 117. There's a bare denial of the claim for the account, and then time is taken in paragraph 107. Any of the claims made in respect to the breaches of contract and duty set out in paragraphs 96, 98, 100 and various others, 96 being the allegation of breach of fiduciary duty, to the extent that any such alleged breach occurred prior to September 2010 must be time barred, if which is denied any breaches occurred prior to that date. They occurred more than 6 years prior to commencement proceedings, time barred according to various provisions of the Limitation Act and or by analogy. So no plea of laches, no plea of acquiescence, no plea even of unconscionable delay as it's now being put. And indeed the judge recorded that the plea had no effect. That's in her first phase judgment, paragraph 466. Consequential on that judgment, Mr. Justice Cockrill made orders holding that there was a judgment on issues of liability. She ordered that the claimants were entitled to elect between an inquiry or an account of profits. The claimants elected for an account. They did so on the 14th of February 2019. Accordingly, by the time of the phase 2 trial, there was no doubt that an account had been ordered, no plea of laches having been raised, no plea of acquiescence having been raised, and no, as I've said, plea of unconscionable delay. The defendant's position paper then raised that for some of those and it's worth just looking at that very briefly, so we can put away the supplementary volume and go at least to core bundle 2, tab 15. And that's the re-amended position paper. At page 301, one sees in paragraph 1 that the document sets out the defendant's case, bless you, it sets out the defendant's case as the proper scope of the account of profits. It took for granted the fact that an account had been ordered, and there were similar concessions in paragraph 2. The liability of each of the defendants to account is several, and paragraph 9.1 at page 304, bottom of the page, the claimants are entitled to an account of only those profits net of expenses which are causally or sufficiently connected. And the plea in relation to time appears in paragraph 20 on page 311, subparagraph 2. And the way the plea is put is the fact that Mr. Jaffe, and through him the claimants, waited for 5.5 years following the breach of the fiduciary duty to see whether, at no risk to himself, value could nonetheless be generated and obtained by the individual defendants from the opportunities that were the subject of the recovery services for commencing a claim for the recovery of the profits thereby earned, should, and one sees that from the header for paragraph 20, be taken into account. So that's the nature of the plea. Then, by way of re-amendment, at paragraph 20, subparagraph 5, over the page 312, a plea of unreasonable and unconscionable delay was made, and then that was said to be acquiescence and laches in the subparagraphs A and B that follow. Overall, the oddity about both of those pleas is that at no point did the defendant seek to identify the date by when various things should have happened. Those matters were left entirely vague. No plea as to the date by when proceedings should have been issued, no date by when Mr. Jaffe should have obtained protective measures, and one sees the reference to protective measures in the rider that follows subparagraph 5. The account should be limited to the period between the breach and the time at which Mr. Jaffe should, in the court's assessment, commence the claim or taken protective measures. Now, what is important, though, is not only the absence of timing, but also what was expressly being said should be done. And what was being said then was the commencement of the claim or the taking of protective measures. Now, as the court knows, the judge, in any event, held that the question of laches or acquiescence went to the issue of whether or not an account should be ordered, and accordingly it was not open to the defendants at phase 2. That's paragraphs 291 to 330 of the phase 2 judgment. We say she was entirely right to find that laches and acquiescence only go to the ordering of the account, not to the scope of it, and Mullen and friends on this appeal don't seek to say the contrary.
Well, Prince, we may be in danger of using labels to obscure principles.
They say delay should be taken into account. Absolutely, I accept that.
They do, and they label the delay here in subparagraph 5 as laches.
Well, they have two independent bases. They don't say that they can satisfy, for example, the detrimental reliance elements of laches and acquiescence. They don't plead that, and they don't seek to prove it. What they seek to do is say, simply by delay, which they will then describe as being unconscionable, they should be entitled to have the scope of the account reduced. And our answer in relation to this element of the appeal in a nutshell is this. What the defendants seek to do is to use timing in a way that is inconsistent with the reasonable relationship analysis that I've outlined earlier. And in essence, what they seek to do is they say it's separate and independent of the reasonable relationship, and the court should then look at that issue independent of the reasonable relationship question. We say the judge adopted the appropriate and orthodox approach of saying what's the reasonable relationship. Elements of time might arise. So, for example, in a different case where a fiduciary mixes their own funds with the funds of the trustee, or of the trust, the question may then arise, as time goes on, to what extent can the funds being held by the fiduciary still be related to the funds that were in the trust?
Well, I understand you say that's the explanation, for example, for Warman.
Yes.
But that isn't introducing any element of fault in relation to standing by or not commencing proceedings or not taking other steps. That's entirely separate. And as I understand your submission, it is that there is simply no room for any consideration of fault in delay in taking such steps in relation to the scope of the account.
Absolutely. I say there is no scope. The scope for taking an unconscionable delay into account is at the laches and acquiescence stage, which is in relation to whether or not there should be an account. So that's the defendant's position paper. Then one can put that away and go to the judge's findings, which are in 4111, tab 9, page 245. And one picks this up at paragraph 630. So she observed that she found that the issue was closed, but even if it had been opened, I would have found that the remedy was not barred, essentially because here one is looking at a very different vista to that which has pertained when delay has bitten in the authorities. We'll look at the authorities in a moment. But what she finds, crucially, it is in paragraph 631, in the cases, inequitability has gone beyond waiting and seeing. And she says in 632, the present case is not equivalent to such cases. So even if the court were to find that inequitability is sufficiently shown by just waiting and seeing, she goes on to make findings of fact. And the findings of fact that she makes follow on from the second sentence of 632. The recovery services were not inherently risky. While working in this milieu may carry risks, and I noted above the evidence to that effect, the recovery services per se were not risky in the sense that we see in the authorities, nor was there risk of no outturn. It was clear, it was well known to all, there were assets, many of them, and Mr. Schvidler's evidence was clear. On any analysis, the family were billionaires, or as he put it in another passage, the family were asset rich, but cash poor. There was no uncertainty. Realistically, there would be some very significant recovery. And then the judge looks at the paradigm case, the operation of the delay principle in the mining cases. Upfront commercial risk or investment was required to pursue the opportunity. This was not such a case. Again, we say that's a clear finding of fact. The element of real serious commercial risk shouldered by defendants and deliberately dodged by Mr. Jaffe was lacking. Again, we say that is a clear finding of fact. And those facts are sufficient to answer this appeal, whatever the court's view on how delay might be involved in the shaping, fashioning of the account. And then further, while I do, as urged by Mr. Cogley, treat Davis with a degree of caution, and Davis is a case where there are letters written warning of what's going to happen, I do tend to agree with the deputy judge in that case that there's a distinction between the maintenance of a right as per Clegg and a clear shot across the bows as to future litigation, as here and in Davis. I should make clear that the outcome does not hinge at all on the latter point. That simply adds weight to a conclusion that she would have reached in other ways. There's also a real sense in the Leitch's acquiescence case of the unconscionability deriving in part from the delayer avoiding making his or her own contributions. And that was not this case. The defendants kept the claimants out of the opportunity, and the claimants wanted to be involved in the opportunity, but were prevented by the defendants from doing so. So when we come to look at Clegg, one sees that that's a very different situation to the situation in Clegg. This is not the case here, the judge finds. In large measure, Mr. Jaffe was not even dodging work he would otherwise have personally done. It was the essence of the individual defendant's original discontent. The model for the recovery services via SCPI was one where Mr. Jaffe retained overall direction, but did not put in the hard yards. Then 636, a huge amount of time, attention and money was focused on the question of Mr. Jaffe's ability to start the litigation earlier than 2016. Again, the entire argument rested on extremely slim foundations, but then she goes on to find the findings of fact. Had it been relevant and live, Mr. Jaffe was financially able to commence some form of litigation earlier than he did. The case that he could have afforded to commence litigation, or this heavy litigation, was not made out. And why? Not least in part because his outgoings hadn't been analysed. And then 638, one sees that even if she was wrong on that, she concluded on the balance of probabilities that it had been possible for him to commence proceedings earlier. She would in any event have concluded that he essentially took a commercial and strategic decision to wait, at least until the outcome of the VDP carried interest litigation, before he did so, and that decision was a reasonable. Now, my lords, my lady, those are findings of fact which cannot be properly challenged on this appeal. The burden's on the defendants to show why unconscionable delay should prevent the form of remedy that was being sought, if they're right that they could bring in delay at this stage of the proceedings. Moreover, it is important to note that the allegations being made by the defendants were framed by reference to Mr. Jaffe, not in fact by SCPI or the corporate claimants who ended up pursuing the claim. Because it's important to bear in mind that SCPI would not necessarily have been the party who pursued the recovery services. It might have nominated either of the two claimants who brought the proceedings, in fact. Now, we submit that in circumstances where the judge has made an unappealable finding of fact that the decision was a reasonable one not to commence litigation, it is very difficult to see how equity can then seek to intervene to say, well, despite the reasonableness of that decision, nonetheless, some form of vague limit should be placed on the shaping of the account. Moreover, it's important to look back at the findings in relation to Mr. Jaffe's conduct in 2011. And if the court could go, please, to paragraph 63 and 64. That's page 140. One sees why Mr. Jaffe decided at the end of summer 2011 not to commence the litigation. He decided against suing the defendants. At this stage, it was about the commercial interests, not his finances. In essence, it was because his own interests were aligned with those of the family, points in mind with the outcome of the Berezovsky trial and the VDP exit. His evidence was that suing the defendants at this stage would be acting like an elephant in a china shop. While the defendants urged me to reject this evidence, it rang true. The period appears to have been a hiatus while Mr. Jaffe indulged in a lot of angry communications and, as he would put it, nursed bad thoughts, but while he also pondered what the best way forward was for his interests. But further, it's self-evident that it was not yet clear that the defendants would themselves achieve a deal with the family. There was therefore a commercial side to the decision to hold fire, as the defendants positively asserted. And then just over the page at 66, it follows that not launching proceedings at this point is something which cannot fairly be categorised as delay for the purposes of an unconscionable delay argument. And again, we say that's a finding of fact by the judge. Now, against those clear findings of fact, what is the defendant's case? First, the defendants now claim that things might have been different if a claim had been started earlier. And my learned friend sought to give those answers in answer to the court's questions as to where the unfairness lay. Now, to some extent, this is a new case, not raised before the judge. There is no pleadings or evidence from the defendants as to what they would have done differently. And we say that your lordships and your ladyship should not at this stage entertain this new claim. Their complaint was that Mr. Jaffe should have taken an assertive step to advance SCPI's claim, including by bringing an injunction application. We've seen that from the position paper, and it's also in their closing submissions, paragraph 529. That's supplementary bundle 2, tab 33, page 517. But in relation to the injunction, my learned friend Lord Wilson effectively abandoned that suggestion yesterday. That's day 1, page 99, line 20, to page 100, line 1. And he said clearly, being realistic, although an injunction is an available remedy, in the sense of something to go for, there are going to be real difficulties. But the burden was always on the defendants to show that starting proceedings earlier would have made any difference. But what are the options? Either they would have stopped and made no profit, or they would have continued as they have done and did. The court has no idea what evidence they would give in relation to those two possibilities, because neither of, in any of the incarnations of the position paper, did the defendant seek to explain what would have been different. And we say, in those circumstances, what is unconscionable about the claimants having a remedy in the shape that the court fashioned it below? It's quite different where the claimants or a claimant has not tried to participate in the venture. That's Clegg. That's where it's unconscionable, where they stood by and did not want to be involved. In our case, we were kept out. In fact, if one was going to undertake this type of analysis now, which we say you shouldn't, it's reasonable to infer that the same dance would be done. There would have been a denial of duty, there would have been a trial as to liability, there would have been a phase 2 as to the account. In those circumstances, what is the detrimental reliance what is the unconscionability here? Now, what may be said by Lord Wolfson is, well, we might have been able to say, if proceedings had started earlier, that any profit is too speculative. Well, how unjust would that be for a trustee to be able to say in response to a claim by the beneficiary, look, it's all just too speculative. Let me take this business opportunity. Let me develop it. Let me, as we now know, make huge sums of money. But because of the timing at which you bring the claim, you can't prove that you've got an account, and therefore the account fails. And we say that would fall foul, clearly, of the deterrent effect principle. This is not a case in which the defendants can show that they invested huge sums of money. It's not a case where they've undertaken a speculative venture by exploiting a mine, where they might end up receiving nothing. As I've shown the court, the judge's findings were that this was not a risky venture. There was money to be made here. Much reliance is placed on the URSA hurdle and the $500 million hurdle. We didn't know about that hurdle until disclosure during the course of these proceedings. And that was a hurdle that the defendants set for themselves. They can't say at the same time, well, we think it's jolly unfair that we've got to account to you because we set ourselves a hurdle in conjunction with the family above which we could make very, very serious and significant returns. But you shouldn't be entitled to share in those returns because of the hurdle that we, in fact, agreed to.
On the question of risk, the judge, defendants rely on fact earlier in her judgment, the judge refers to, I think, extreme and indeterminate risk. Words to that effect. Were you going to address that?
My lady, yes, my reading of the judgment is that she doesn't find that there are those types of risks in this case.
Okay.
And what she's finding is that those are allegations that are made as to the risk, but as I've shown the court, the finding that she makes are ones that it's not inherently risky, sufficient to mean that...
I've seen that. It's just earlier in the
Yes.
judgment.
Can you just remind me where it is?
Where
it is earlier in the judgment.
118, I'm prompted.
Thank you.
So that's in relation to the URSA. And so what they say in relation, what the judge says in relation to the URSA, that's a far from straightforward document, it reflects no great credit on its drafters unless they were actually seeking to confuse readers. Then the URSA and the term sheet, which Mr. Jaffid advocated pre-breach, were rather different. And then one goes to the end. The URSA was a less beneficial deal than the term sheet. It gave the defendants the right to receive sums of money, but only when the family had received proceeds exceeding the carried interest threshold. In other words, it incentivised substantial success. But I'm not sure if that's the passage that your ladyship is looking at.
Well, it is. It's in the middle of the paragraph.
I'm sorry.
It refers to extreme, and the risks placed on the defendants were extreme.
I see
It's
that.
obviously relating to the URSA, the terms of the URSA, but I'm just reading that.
I apologise, my lady.
References you would.
Yes, we say that it was the deal that in this case the trustees entered into, or the fiduciaries entered into, was such as to set themselves a hurdle for the purposes of making a recovery. Why should that hurdle prevent the beneficiaries from being able to make a recovery? Certainly, why should that be taken into account for the purposes of determining whether or not there's been unconscionable delay?
Well, a key point is you've made the point that you weren't aware. Is that tied? Can we tie that down to the evidence?
Now I can't, but I will.
Right,
I will
thank
show
you.
my lady that. But I don't think there's any dispute. It was disclosed in very redacted form during the course of these proceedings.
It's not quite the same as the finding that you weren't aware of it.
I see that, but I will check. The other section on risk is at 451 and following, at page 211. Which is whether the defendant took significant financial, commercial and personal risk. And maybe this is an answer to your ladyship's question. What the judge was looking at in relation to the URSA was looking at the risks that the defendant set themselves. What the judge is doing in 451 is seeking to identify whether they took significant financial, commercial and personal risks for the purposes of the equitable allowance element of the claim.
So you're saying effectively the earlier reference is in a different context,
Absolutely.
specific to the terms of the to the commercial deal they did with the family.
Exactly, my lady. Because what the judge then does in the context of this particular issue, she finds that the evidence on personal risk was not persuasive. That's in 452, and she sets out the reasons for that. And then in 453, she says that the risk is one that the defendants agreed to becoming involved in the recovery services initially. So that's in relation to personal risk. Then in 454, as for the financial and commercial risk, again I accept a degree of risk, but that degree has to be assessed. And then she continues down, and I won't read it all to the court, but she concludes that they were effectively betting on a certainty. And then she cites Mr. Schvidler's evidence in paragraph 454. So we say, as against...
So
Sorry, my lord.
your submission, if I've understood it, which I may not have done, let me try and articulate it to see if I have, is that the judge found that there was an extreme and indeterminate risk in the event because of what happened in URSA and what they undertook that they would have to achieve in order to get the profit. But when it came to the analysis of risk for the purposes of equitable allowance, that wasn't the relevant question.
Yes.
The relevant question is what the risk would have been in earning the profits had the opportunity been exploited by SCPI.
Well, I don't think that...
I'm not sure I'm seeing the distinction.
Yeah. So the distinction, my lord, is this. What the judge was saying in relation to the URSA is, in order to satisfy the terms of the URSA, there was a risk. But the risk was not such as to mean, from in terms of unconscionability, that a remedy should be refused. So she makes the finding that there's an indeterminate risk in 118, but she then goes on to say, how in practical terms does that impact? Well, she doesn't say that. She then says, in practical terms, how does the element of risk impact on my findings as to unconscionability and delay?
The section we're now in, 452, is equitable allowance, isn't it?
Yes, my lord.
You're referring to it, obviously, in the context of the delay appeal.
Yes, because she looks overall at the issues of risk, and she makes findings as to the particular element of the URSA, which is used by the defendants as the thing to kick their recovery into place. She doesn't say that the risk of kicking the recovery into place is sufficient to mean that it's either so risky a thing for the purposes of allowance, nor so risky for the purposes of unconscionable delay. And one can see the sense in that, because otherwise what one says is, if a fiduciary decides within their own sphere of knowledge to set particular hurdles for recovery, why should that prevent the trustee? Why should that prevent the beneficiary from being able to make a recovery?
I'm sure the defendants would say that that's the deal that they were able to do with the family.
And they may say that, my lady, but they didn't seek to explain what lesser deal, what lesser reward they could have received. The question then, should they then be able to step scot-free and have everything, is a very different question. And that's effectively the case that they seek to put forward. So we say the findings in relation to the URSA don't provide the answer because the judge goes on to look in detail at the issues of risk by way of allowance and the risk by way of also by way of unconscionable delay. But standing back, one then always has to say, so what? And what the defendants now seek to say is, if they've been on notice that there was a need to account or to allow us in, something might have been different. And that was my learned friend submissions from yesterday. But again, we say that's a new point. It was not articulated in that way in front of the judge. And it's unclear why that should be so in circumstances where, as I've said, the claimants wanted, and SCPI wanted the opportunity to be able to exploit the opportunity and were prevented by the defendants from doing so. Moreover, again in the context of unconscionable delay, the defendants have never adequately explained what should have happened. We've seen that the injunction has gone, effectively, for good reason, because plainly an account would have been an adequate alternative remedy. Plainly there would have been problems with the cross-undertaking. Moreover, there was an innocent, or ostensibly innocent third party, the family, who wanted services to be provided. It's not, in those circumstances, open to the defendants to seek to disassociate the costs of the injunction from the costs of the overall proceedings. And we know the proceedings at the first stage cost £5.7 million. That's Supplemental Bundle 1, tab 17, page 152. So then standing back, what's the evidence and what's the basis for the case? If the basis for the case is simply on the basis of paragraph 118 of the skeleton argument, 118 of the judge's judgment, we would say that's not a finding that these defendants would get nothing. It's not a finding that at that moment in time, or from that moment in time, there is no reasonable relationship between the profits made and the breach of duty. Indeed, that was an argument expressly articulated by the defendants. So they said the URSA was a break in the chain of causation, or the chain of reasonable relationship. And the judge held no. So in those circumstances, to bring back that finding into the context of unconscionable delay would, we submit, be inappropriate. Not least in circumstances where the court has seen the expenses that were claimed and paid, some of which were included in the account and some of which were excluded. But overall, we say the judge's factual findings on the issue of delay are clear, they are correct, they are not open to challenge in this appeal, and this court should effectively draw the line at that moment. That's what I want to say in relation to factual background. And if I could move on to the law. We deal with that in our skeleton from paragraph 31 and following. The defendants don't advance a case on the basis of laches and acquiescence. It's now pure delay or pure unconscionable delay. And we say for laches, something more is required than mere delay. And here we say nothing more is relied upon. And the fact of the absence of anything more explains why laches is not pursued. And the point that we make by way of overarching submission in relation to the law on these issues.
Sorry, forgive me, what's the anything more that's missing?
Well, normally some type of detriment.
Well, it doesn't have to be. I mean, don't the case put it in terms of unjust?
They do. I accept that.
I mean, not necessarily detriment.
Not necessarily, but one needs to look and identify very clearly what the injustice would be.
Yes.
And Here we say that injustice has never been articulated. What is the injustice? What would they have done differently? What is the reason why, merely by waiting, the claimant should be excluded from any form of remedy? So I accept it's not only detriment, but something more. And here, the something more remains elusive.
Well, I think it said it's the assumption of risk, just the same way as it was the assumption of risk in Claimant.
But that would be all. That's all cases where someone seeks to then exploit a maturing business opportunity.
But what was the detriment in Clegg then?
So Clegg was different. Clegg, there the detriment was the investment in the mine in circumstances where the mine might not end up being a valuable opportunity at all.
That's what I mean by the risk. Here it said it's the expenditure and work on providing the recovery service in the circumstances in which there was extreme and indeterminate risk as to whether they'd reached the threshold.
As to whether they reached the threshold, yes, but in terms of other elements, we would say no. But they were being paid management fees, and I showed the court the management fees yesterday. So it's not that expenses in the way in Clegg would be irrecoverable.
But forgive me, it's my fault for the way I put it, Chris. I'm not really asking whether they've made out a detriment or not. You're saying they've never sought to allege a detriment, which they'd need to for late cheese, and therefore that's the end of it, as it were.
Well,
and I'm not sure whether that's right, is it?
Well, what I would say is that when one looked analytically at how they were relying on what happened, they relied on that in the context of their allowance for reasonable skill, or rather unique skill, exceptional skill. They didn't seek to say, simply because we had to do these services, we should be entitled to say it's unconscionable for you to recover.
Well, they pleaded it as late cheese, so there we are. Anyway, I understand your point.
Looking at the cases, looking at the mining cases first, there are two cases, Clegg and Grunt. We say the judge rightly analysed those two cases as cases where profits had been made by a risky process or investment, and crucially, the plaintiff has chosen not to accept the risks and has sat on their hands until it became apparent whether there would be profits. And we say that's the injustice. The injustice is not deciding to participate. And one sees that in the judgment at paragraph 304. At page 182, core bundle 1, tab 9, paragraph 104. And one sees that towards the end of that. The authorities make clear that whether delay produces an equitable defence depends upon whether it would be inequitable to do so. That itself seems to trace back to the questions of whether the profits have been made by a risky process or investment, and two, clear knowledge of the conduct of the business can be shown, such that it can be said that the claimant has chosen not to accept the risks, but has rather sat on his hands until it became apparent whether there would be profits. One can appreciate that inequity. Now, iniquity. And the judge has made a factual finding that this was not such a case. It was not a case where the claimant has chosen not to accept the risks. The claimant didn't, in this case, sit on his hands until it became apparent that there would be profits. And the judge then seeks to now analyse the case in paragraph 305. And one looks at what the judge has said. One sees in the middle of that paragraph that relief was barred by late cheese and acquiescence because the claimants knew the defendants intended to apply for a new lease and could have done so in the same way themselves. And that's a crucial, we say, interpretation of Clegg, which is right. As I showed the court yesterday, in this case, the defendants had encouraged and colluded with the family's disenchantment with SEPI, and that was part and part of the disloyalty. That's judgment paragraph 393. So this is a very different case from Clegg. Then one looks at how she looks at 602. Considerable stress was placed on the fact that mining property is subject to extraordinary contingencies and which can be rendered productive only by a large and uncertain outlay. And we'd say again, this isn't a case where there is a large and uncertain outlay.
Sorry, where are you looking?
Sorry. Still in the judge's judgment,
Yeah.
page 182, at paragraph 305,
Oh, sorry.
where she quotes from page 602.
Oh, I see.
And she cites in particular the extraordinary contingencies and which can be rendered productive only by a large and uncertain outlay. And we say that that's an appropriate approach to adopt to Clegg. And that's why, at its core, the judge was right to reject the analysis between Clegg and this case.
I have some difficulty in drawing such a clear distinction between an investment of money and investment of another asset you may have, namely your labour, your services. And in a situation where here, as I understand it, the defendants have committed to perform mandatory tasks for an indefinite period. And that's an investment, isn't it? You're investing your time and labour, which you could otherwise, it's your another form of capital that you might invest rather than money that you could have invested in another project.
What we would say is, in this context, one then has to marry up the existence of the allowance with the existence of the risks that are then being incurred. We say there is inherently a difference between outlaying one's own money in circumstances where the beneficiary doesn't want itself to make the investment, with the situation where a beneficiary wants to undertake the business, but the trustee decides to undertake the business for themselves. At that stage, is it unjust by reason of delay so as to prevent the beneficiary from having a claim? The answer, we would say no.
Well, isn't the wording, the claimants were aware of this but allowed the defendants to work the mine without interruption for 9 years? I mean, exchange the mine, it's a different sort of mine. The family's assets, mine the family's assets, as it were, for 9 years. I mean, isn't it an almost exact parallel?
Well, we'd say no, because the structure of the relationship between the family and the defendants was very different. There were loans going back and forth. There was money being paid to cover expenses. The expenses that were claimed by the defendants in some part were allowed as the part of the account. So it's not that there is a situation here where money is going out just by the defendants without any possibility at all of recovery. What the defendants were doing was they were expending money, they were being paid money by the family. The question then arose later, to what extent should the defendants be required to account to the claimants for the monies that they had received? So it's not the situation of investing in a mine where there may be no return at all, because there is an ongoing return.
As I understand it, the arrangement was such that recoveries had to exceed almost £1 billion, didn't they, net, in order to have a recovery. Sorry, in order for the defendants to start receiving their carried interest.
Well, my understanding is it's a 500 million, the threshold was a 500 million threshold.
But wasn't that, didn't that have to take into account that monies were due to Mr. Berezovsky and Mr. Abramovich, etc.?
I'm afraid I'm not, the answer to that, I don't know, my lord.
I was just looking at 118. maybe a bit ambiguous.
Yes, so I understand.
So 117, sorry.
I understand that your lordship's right. The issue then is that these people were billionaires, and so that's where Mr. Schvidler's evidence becomes relevant, because he is saying, yeah, they were. It looks high, but fundamentally they were betting on a certainty, because these people are billionaires, so they will be able to recover this sum. And what one sees in 118 is that it's about the receipt of the carry, not about the receipt of the expenses that would otherwise be achieved. So what's being said by the judge is, to get the bonus, the carry, they need to meet the threshold. But expenses were, in fact, under the agreement being paid, and management fees were being paid on a regular basis.
For my benefit, at least, it would be helpful just to have very clear reference to the management fees and the expenses being paid. I think we've been taken to it in passing, but I haven't at least got that point very clearly.
If I may, I'll pick that up after the short adjournment.
Yeah.
And that's probably the easiest way to show my lady exactly what's happening.
The way I read this is that the judge's reference to risks being extreme and indeterminate is because they had to carry out tasks indefinitely in the event taken to 2015, and then C, broad management obligation in respect of assets that were not sold and no guarantee they could secure separate remuneration, and all that against the background where they wouldn't receive 15%, which is presumably what they're really after, until the family had recovered not only the 500 million net after settling the liabilities to Mr. Berezovsky, David and Olga, and third parties, including a loan of 298.5 million from Mr. Abramovich. So that's why she regards it as extreme and indeterminate.
Yes, in terms of getting the carried interest, yeah. But that's not comparable to the mine example, where here, in the mine example, someone is making the investment with the prospect of never being able to make the recovery. What's the investment? The investment is time and money and kit. Here, what is extreme and indeterminate by way of risk is getting the 15%, not getting the management fees that would otherwise be payable. And to that
the management fees, as I say, the trouble about that is that the family is asset rich but cash poor, and that's why the defendants are actually making loans. I mean, they are making an investment. Yeah. They are investing cash as well in the form of loans into this family. So, to what extent they can take comfort from receiving fees is unclear, and it seems to me that the big risk here is that things don't turn out to be quite as hoped, and the family's assets aren't quite as large or quite as easily recoverable as had hoped. Just like the mineral or whatever you're mining for is not as plentiful or as accessible as you'd hoped. No doubt the reason you're undertaking the mining is that you have reason to believe there are thick seams of valuable metals there.
I see that, my lord. But what then one has to say is, what were the judge's factual findings in relation to this particular transaction? And there one goes to 454 at page 212. And we see that the judge accepts that there's a degree of risk, and I don't seek to say that there's not a degree of risk, but if one carries on in that paragraph, there was a degree of commercial risk and the defendants for some time did not know how well remunerated they would be. And we say that's quite different from a mining situation where it may be that there's no ability to make money at all. And you then have, in the context of this very question, in 632, at page 245, the finding that I showed the court a moment ago, that they were, the recovery services in themselves were not inherently risky. Why? Because there was no risk of no outturn. It was well known that there were assets. There was no uncertainty. Realistically, there will be some very significant recovery. So we say that that is quite different from the mining cases.
So just pausing there, how do we square that with 117 and 118? Is that to be read as meaning, realistically, there'd be some very significant recovery, but not by way of carry interest? That was a matter of large and indeterminate risk.
What your lordship can read is that 118 is saying, on the terms of the agreement itself, then the risks were extreme and indeterminate. But once one then factors in...
Meaning the risks, they wouldn't receive any carry.
Any carry, yes.
But so, you're referring very specifically to the contractual terms there. I think you're reading it as looking at those terms without reference to the judge's finding that in fact the family were billionaires.
Yes,
so it's all going to come good. I think that's what you're saying.
Yes, my lady, that is the analysis. Because that makes it clear what is being said. What is being said is that it's any carry, that's the first point. And the second point is it's not done by reference to the underlying facts of the case, because she then goes on to look in the relevant context at the underlying facts. She looks at it in the context of unconscionable delay, and she looks at it also in the context of allowance. So one shouldn't take out of context the finding in relation to the extreme and indeterminate risk for carry under the URSA from the risks that the recovery services themselves contained. And that's why the mining cases aren't apposite to us.
I'm still perplexed because I think what you've just said isn't quite what my lady said. You could read 117 and 118 as meaning simply as a matter of contract. If you looked at the contract, the prospects of, or the risks of not getting any carry interest under URSA were extreme and indeterminate. But look at 454 and 632 on the facts, that wasn't actually a risk at all. Is that what you're saying?
Yes, my lord, it is. I'm sorry if I've been confusing. But yes, that is what we say. We say 117 and 118 is looking at the agreement itself.
Yes.
It is looking at how much will they get. That is not clear. And that is the reference to carry. But when one then stands back and says, will they get something? The answer is yes. And will they get something that is pretty substantial? The answer similarly is yes. And that's what one then gets later in the judgment where she looks at the issues of delay.
Whether by way of carry or not.
Whether by way of carry or not, absolutely.
All right, thank
you. In relation to Clegg, we say that that's a case about late cheese. It's a case about late cheese such as to mean that it is about ordering the account, not the scope of the account. And that's the answer in general terms in relation to Clegg. If I'm wrong on that and it is some way involved in working out as to how one fashions the account, the judge is right in that it is looking at extreme risk as leading to an unconscionability. And this was not a case of extreme risk sufficient to mean that it's unjust for the claimants to be able to recover the full account that the judge found was appropriate in this case. So that's Clegg. In relation to Grunt, that's analysed by the judge at paragraphs 312 to 315 of her judgment, and that's in Core 1, tab 9, page 183. And we say that the judge's analysis is right. She observes that the basis for the decision is not clear. It's obviously an Australian case, so not binding on her or indeed on you. But when one analyses the case, it's not clear as to how the position was reached. Again, we say it's not a case of a temporal limit being imposed at the scope of account phase. It's about deciding whether or not, as a matter of estoppel or laches, the remedy was barred. And that's not what this case is about. There are three further Australian cases that my own friend relies on. The first case that he relies on is Warman. That's Authorities Bundle 2, tab 13, page 355. And we say there are 2 points to be made in relation to Warman. The first is that its outcome and its analysis is well explained by the judge at paragraph 406. And that's at Core 1, tab 9, page 407. Sorry, page 203, paragraph 407. So, in the context of insufficient connection, she refers to Warman at the end of paragraph 407. And there she says, to the extent that this was advanced as a discrete issue, I'm confident that there was no basis of the approach. It appeared to be a reverse engineering analysis, designed rather to pull forward the closing point of the account to a point when the defendants would have to make no payment than to reflect a temporal cut-off deriving from a principle. The application of accepted principles may lead to a conclusion that for reason A, sufficient connection disappears by date Y, and that for reason B, it would disappear by date Z, leading to a consideration of whether date Y or date Z or indeed date X is the appropriate date to terminate the account. This is what happened in Warman, but unless those principles can be engaged, the point cannot arise. This therefore does not fall to be dealt with as a separate issue. So there the court looks expressly at the question of the point in time by which no sufficient connection can arise, and the judge finds that that is consistent with the approach in Warman. And we say that that, as I think I've already said, is consistent with Murad, paragraphs 116 and 117. It's consistent with the decision of the Supreme Court of New South Wales in Murdoch at 196, and it's consistent with Chief Justice Elias in Churnside. That's the first point on Warman. The second point is that the point of principle, we say in Warman, insofar as the court wants to pay any attention to it, it is clear and it doesn't assist. And that, one can see, if one could just take up the authority very briefly, it's Authorities Bundle 2, tab 13. I'm interested in page 371. And the court was shown this passage during the course of my own friend's submissions yesterday. And the point that we would make here is that the court is looking at whether or not it is inequitable to order an account, not to shape the account. And one sees, although an account of profits, like other equitable remedies, is said to be discretionary, it's granted or withheld according to settled principles. It will be defeated by equitable defences such as estoppel, laches, acquiescence, and delay. Conduct of the plaintiff may be such as to make it inequitable to order an account. Thus, a plaintiff may not stand by and permit the defendant to make profits and then claim entitlement to those profits. And we say that is the statement of principle insofar as anything is relevant from Warman. And we say that that is consistent with the judge's findings at the Ship at Sale. The second Australian case on which my own friends rely is the case of Edmonds and Donovan, which is in the same bundle, tab 16. The judge rightly found that this was a case about acquiescence. She found that in judgment paragraph 298. It's the case involving a business opportunity involving a golf course purchase and redevelopment. And there, in this case, the first instance judge had refused the remedy sought, which was a constructive trust, at least in part in relation to delay, and instead sought to award compensation, equitable compensation. And one sees that from paragraph 68 of the judgment at page 488. Then there was some confusion about the nature of the particular remedy, and the court yesterday asked as to how the 4626 analysis came about. It may be that it comes from paragraph 69 of the judgment, where what the judge did below was to rule that the respondents who receive 4/6 of the value of the property and of the profits made plainly a reflux of the earlier determination that Edmonds and Cahill should be treated for all intents and purposes as if they were each a 1/6 member of the joint venture as originally agreed. So the judge was using, for the purposes of assessing equitable compensation, the previous approach that had been adopted as to profit shares, as between Edmonds and Cahill and the others. Now that is consistent with the approach that the judge adopted in relation to antecedent agreements, because it shows where there is an interest in the property, then the interest can be reflected. Where there is no interest in the property, then it cannot be. What the court then did was to refuse the account simpliciter. One sees that from paragraph 75. The judge faced a difficult task in devising an appropriate remedy. Nonetheless, it appears to be simplistic to me to suggest that the appellants were liable to account to the respondents for all profit made from the subsequent exploitation of the venture. Of course, allowance had to be made for all proper expenses and the like before arriving at profit made, but even so, to regard that resultant profit as attributable only to the so-called theft, and therefore to order an account simpliciter, would have been to disregard too much of the surrounding circumstances. And so we say that was the basis, again, of, at least in part, the analysis. So it's entirely looking at the profit, effectively the causative link. And finally, one sees in paragraph 82 that this is a case about acquiescence, and one sees that at page 493. The third Australian case is Murdoch and Mudgee. That's Authorities Bundle 4, tab 35.
Sorry, what paragraph number was that?
Sorry, that's 82, my lady.
82, thank
Page 493. The respondents not merely stood by for nearly 2 years without attempting to intervene, but thereby acquiesced in what was happening, if not indeed to the point of adopting it. And the third Australian case is Murdoch and Mudgee. That's Authorities Bundle 4, tab 35. It's considered by the judge at paragraphs 318 to 321. She was right to consider that it did not advance the defendant's case. It was drawing on Warman and Edmonds, both cases being cases about acquiescence, as I've shown the court. And in that case, as my learned friend showed the court yesterday, the defaulting fiduciaries had stood by, such as to mean that it was inequitable for them to have to account for the profits to the trustees, sorry, the respondents, that the beneficiaries had stood by. If one goes to the authority itself, it's authorities 4 tab 35. I'd like please to pick it up at 1061. And paragraph 195 at page 1061 sets out what we say is an orthodox approach towards the question of timing and delay. It looks at equitable defences such as laches, delay or acquiescence. It looks at them as barring the remedy rather than seeking to fashion it. I accept in paragraph 196 there is discussion about the power being used to fashion the account, but we say again that is about ensuring that there is a reasonable relationship between the profit and the breach of duty. It is not about saying that there's a freestanding independent right which then intervenes irrespective of the link that may be established between the profit and the breach of duty. And indeed in 198 the court refers to the discretionary defence of standing by, leading it to be inequitable to recover profits, and refers to Edmonds and Donovan and Jarvis. Jarvis is a case about laches, so again we say those cases are all consistent with this being a line of argument that needs to be run in order to prevent the account as by way of defence, not by way of shaping the account as the defendants seek to do. I've dealt with Jarvis. That's a case about laches, and that's clear from the head note itself. That's Authorities Bundle 1, tab 7, page 134, and also from the sideline passages at Authorities 1, tab 7, page 139. Finally, by way of cases, there are the 3 intellectual property cases. The judge considered one of them, Ford and Foster. The other 2 weren't cited to you. Her analysis of Ford and Foster is unimpeachable. That's judgment paragraphs 316 to 317. As I understood, it wasn't challenged by Mullen and Friends. In relation to the other cases, they demonstrate particular aspects of IP law and do not assist here. For example, in relation to Edward, Young and Holt, that's Authorities 1.5 at page 107, one sees the court citing the difference in approach, at least the approach that's adopted in the IP cases, because the complete innocence of the defendant in an IP case may be a reason for limiting the account of profits to the period subsequent to the date at which he becomes aware of the true facts. So a different approach being adopted to the account, and with respect, we wholeheartedly adopt my lady's point made to my friend yesterday as to the observation of Lord Justice Burse in Lifestyle. That paragraph 7, that judge was considering the application of principles from fiduciary duties to IP cases and not vice versa, and a very different position would apply in this case. Those are the legal points that I want to make. If I can make my submission very, very briefly in relation to this ground, let's see whether I can finish it in the 4 minutes left to me. I suspect not, but I'll do my best. We have 4 overarching submissions. First, we say that the judge was right to consider that any issue of delay was a matter for the phase 1 trial. It was a defence. It should have been pleaded. It should operate as a defence to liability. It cannot and should not be brought into play, again, at the quantum phase in the way in which it's done. Once an account is ordered, then the focus is on factors which include the nature of the property, the relevant powers or obligations of the fiduciary, and the relationship between those powers or obligations and the profit that has been made. To that extent, time or delay on the part of the claimant becomes irrelevant, save insofar as time may be relevant when seeking to work out whether there's a reasonable relationship between the profit and the breach of duty. And we say the judge was right to find at the time to make that argument, if there was an argument based on laches or delay or unconscionability, was at the phase 1 trial, not at the phase 2. That's the first submission. The second submission that we make is, as with the defendant's case on ground 1, the case fails on its facts. Even if delay is to be taken into account, which it does not, there was no culpable delay in this case. And I've shown the court the submission, the findings that the judge made. She would have tended to the view that some form of litigation could have been commenced, but not this type of litigation. She considered that it was reasonable and circumstantial as to how much. The third submission that we make is that the defendants say that based on the judge's findings of fact, the judge was wrong not to hold delay to be unconscionable. And we say that that is not appropriate in this court. No error of principle has been identified as to the judge's approach to the question of unconscionability. Your lordships and your ladyship are exercising obviously an appellate function, and the judge in clear and unequivocal terms reached a conclusion that there was nothing unconscionable about this particular scenario. And as I said, looked at the evidence in some detail, having heard the parties and having considered the facts in much detail. So we say that the judge's findings are unassailable, and fourthly, we say that the defendant's approach is unprincipled and confusing. What the defendants seek to do is to say that Mr. Jaffe's conduct smacks of waiting and seeing, despite the fact that that's not what the judge found. They refer to risks, despite the judge finding that the risks were not sufficient to mean that it was unconscionable to allow the claimants to recover. They say that lawyers' letters are not sufficient. We don't say alone they would be sufficient, but rather what happened in this case was a clear statement as to the fact that if this matter proceeded further, an account might be sought. Similarly, evidence as to the fact that Mr. Jaffe received sums of money during a period of time cannot be a reason to undermine the judge's factual findings. The judge considered the absence of evidence as to outgoings and found that that was not
Sorry, do you
sufficient.
mean Mr. Jaffe received?
Yes, Mr. Jaffe, my lady. So one of the points the defendants ran, and I think run on this appeal in their skeleton, is that because Mr. Jaffe received sums of money, he should have used those monies to start these proceedings.
Oh, sorry, yes.
And the judge considered that and found that that was not a basis on which to find that it was unconscionable. Fifth and finally, the defendants identify a number of possible dates which they say the judge should have adopted. And we've dealt with those in paragraph 42 of our skeleton argument. And we say that the suggestion that June 2011, that's the first point that is taken, as when these proceedings should have started, is unrealistic. It's unrealistic in that what is being said effectively is it became unconscionable thereafter for the defendants to have any money that wasn't liable to be accounted to the claimants in respect of. Immediately after the breach of fiduciary duty, from June 2011 onwards, the defendant should be able to walk clear. That would send a terrible message to fiduciaries as to how they can conduct themselves. That's the first date. The other dates that have been put forward are not pleaded. My learned friend appeared to accept that in his submissions and simply pointed to the defendant's skeleton for trial and the written closing. We say that's not the proper basis on which to pursue a case such as this, where it said after a certain moment it becomes unconscionable, so as a proper, clear guillotine then needs to come down. So the first date doesn't work, that's now put forward. Similarly, the September 2011 date doesn't work, not least because of the judge's finding in the judgment paragraph 66 that not launching proceedings at this point is something which cannot fairly be categorised as delay for the purposes of an unconscionable delay argument. We say she was right in that conclusion. And the other two dates that are put forward were not expanded upon by my own friend in submissions. And we say those are June 2012 and October 2012. and neither of those dates should form the basis for cutting off the claimant's right to an account, not least because the October 2012 date is said to be done by reference to the URSA. But the judge looked at the URSA and decided that that was not sufficient to break the reasonable relationship between the breach of duty and the account that was then sought. So sixth and finally, if I may, what my learned friend sought to do during his closing submissions yesterday was to propose orally a complicated formula by which apparently this court should seek to determine how to split the profits. He suggested that it should be split pro rata, and accepted that it was a bit rough and ready. That's day 1, page 140, lines 9 to 12. It is indeed rough and ready. It is also unprincipled. The judge considered the extent to which certain profits were reasonably related to the breach and made findings to that extent. She conducted the task. Nothing that she's done has been shown to be wrong. The proper and principled approach, as suggested by the authorities, is to use the test of reasonable relationship as the basis for determining whether or not profits are out of time, so to speak, assuming that laches and acquiescence haven't succeeded in relation to liability. They shouldn't, and time shouldn't be used to be shoehorned into the analysis in somewhat is now arbitrary pro-rating method suggested the Court of Appeal towards the end of closing submissions when opening an appeal to this court. I'm very grateful for the court for sitting beyond 1 o'clock, but subject to a few catch-up points, those are the submissions that I would make in relation to the defendants.
Thank you. 2 o'clock.
Of course,